Inside the family justice system of England and Wales, practitioners operate within an environment characterized by immense judicial authority and strict mechanical rules. Upon divorce, the Matrimonial Causes Act 1973 grants the court exceptionally wide discretionary powers to redistribute capital, property, and pensions between former spouses to achieve a fair outcome. Accessing that discretionary power requires navigating a rigid, highly controlled legal pipeline, Part 9 of the Family Procedure Rules. To control this pipeline, Part 1 of the Family Procedure Rules establishes the overriding objective, the core operational mandate for all family cases. This mandate requires courts to deal with cases justly. It demands that parties remain on an equal footing, that legal expenses are saved, and that the court's limited resources are strictly prioritized. This procedural pipeline does not exist to facilitate drawn-out adversarial litigation. It is designed to systematically force opposing parties toward an early, informed settlement. The life cycle of a financial remedy claim moves through distinct phases: pre-action and issue, formal disclosure, and judicial appointments known as the FDA and FDR. This timeline is inextricably bound to the professional codes of conduct enforced by the Solicitors Regulation Authority and CILEx. The legal practitioner acts as the critical interface here. They must filter the client's demands through the court's strict procedural and ethical requirements. The mandatory milestones on this timeline act as pressure points. They strip away secrecy and force transparency onto the financial negotiations. Mastering this system requires complete procedural awareness, alongside an exact understanding of when ethical duties activate during the litigation lifecycle. The process begins under the Pre-Application Protocol, or PD9A. The court expects early, clear information exchange and active negotiation before any formal application is drafted. Making an application to the court should never be treated as a hostile step or an immediate resort. By statute, the applicant must attend a Mediation Information and Assessment meeting, known as a MIAM. Unless specific, strict exemptions apply, such as documented evidence of domestic abuse, the applicant must provide proof of MIAM attendance to proceed. Only after these steps are cleared can the practitioner formally commence the financial order application by issuing Form A. These pre-action hurdles serve a definitive purpose. They filter out disputes capable of private resolution, preserving the court's adjudicative bandwidth for the cases that truly need it. Once proceedings issue, the timeline arrives at its most critical data-gathering milestone: disclosure. This centers entirely on Form E, a sworn, comprehensive account of a party's financial circumstances, requiring absolute clarity on all assets, liabilities, and future needs. The procedural rule here is unyielding. Form E must be simultaneously exchanged and filed at court no less than 35 days before the first appointment. This phase activates an absolute ethical mandate, the duty of full and frank disclosure. In the landmark case of Livesey v. Jenkins, the House of Lords confirmed that failing to disclose material facts can result in a final order being entirely set aside, usually with severe costs penalties against the offending party. A lawyer's ultimate duty is to the court. Practitioners are professionally barred from misleading the judge or allowing a client to perpetrate a fraud by hiding assets. Without the guarantee of accurate, fully disclosed financial data, the entire procedural machinery of Part 9 completely collapses. Occasionally, a spouse believes the Form E disclosure is incomplete and resorts to self-help discovery. A highly suspicious spouse might try to gather further evidence by taking matters and private documents into their own hands. The ruling in Immerman v. Immerman made the boundaries clear. Downloading, removing, or copying private documents belonging to a spouse is a civil wrong and a potential criminal offense under the Theft Act. If a client hands a practitioner illicitly obtained documents, the required response is immediate. The lawyer must not read them. They must seal the documents and return them directly to the opposing counsel. If the opposing party still refuses to provide proper disclosure, the correct procedural route is to apply to the court for formal directions. A practitioner must never sacrifice their professional integrity for a client's tactical advantage. The sanctions for relying on stolen documents are severe and often career-ending. With disclosure filed, the parties make their first appearance before a district judge at the first appointment, or FDA. The FDA is purely a case management tool. It is not a hearing to decide the final financial division. The district judge uses this appointment to determine exactly which financial questionnaires must be answered and which outstanding documents must be produced. The court also takes control of asset valuation, strictly directing the use of expert evidence under Part 25 of the Family Procedure Rules. To save costs, the court exercises a strong preference for the joint instruction of a single expert, actively preventing expensive adversarial battles between competing accountants or surveyors. The FDR operates as a filtration system. It strips away irrelevant disputes so that only the necessary disputed facts proceed to the final negotiation. The entire pre-trial mechanism exists to drive the parties to the Financial Dispute Resolution Appointment, or FDR. The FDR is a unique, legally privileged environment. Offers and proposals made here are strictly without prejudice, meaning they cannot be repeated later if the case fails to settle. Rule 9.17 mandates that parties must use their best endeavors to reach an agreement at this specific stage. The judge takes an active role, listening to both sides and providing a neutral, experienced evaluation of what a final order might actually look like if the case went to trial. Because the judge hears privileged settlement offers, they are strictly barred from having any further involvement in the case if it proceeds to a final hearing. The FDR forces a profound reality check. It strips away adversarial posturing and concentrates the immense financial risk of litigation into a single, highly pressurized negotiation. If the FDR fails to produce a settlement, the procedural timeline splits, and the parties face a grim reality. The case is forced down the path of a final hearing. Governed by Part 27 of the rules, this requires heavily paginated trial bundles, strict time estimates, cross-examination, and rapidly escalating legal costs. The court's preferred outcome, engineered by every preceding step, is the consent order. Drafting a consent order requires precision. Practitioners are expected to utilize the standard family orders, rigorously maintained and updated under the guidance of Mr. Justice Peel. The document must be perfectly structured, clearly separating definitions, recitals for declarations and undertakings, and the substantive, enforceable orders. A properly drafted consent order proves that the Part 9 procedural engine worked. It replaces the risk of a final trial with a binding agreed resolution. Throughout this entire pipeline, from the initial pre-action protocol to the final drafting of the order, a lawyer's professional conduct remains under constant scrutiny. Family practice requires managing a continuous dual duty, advocating fiercely for the client's best financial interests while maintaining absolute integrity to the court. Attempting to subvert this pipeline through non-disclosure, illicit self-help discovery, or misleading the court guarantees severe sanctions and professional ruin. By mastering the procedural milestones of Part 9 of the Family Procedure Rules, alongside the ethical imperatives of full and frank disclosure, practitioners ensure that the court's wide discretionary powers are exercised fairly, efficiently, and with uncompromised integrity.